could be question 5, could be question 6. Okay, so we're going to start with a case brief, and then we'll go to a policy, or we start with a policy and then we go to a case brief. But I want us to majorly discuss those two. Let's start with a case brief. Okay, I've been telling you I'm getting my slides. I have them now. So let me share my screen, and then we discuss a case brief. I think you guys might actually do a case brief. The last time a case brief was examined was a long time ago. So if you get into that exam room and then you see a bulky document, that's the case brief. Because usually if you're drafting a case brief, you have to get a judgment, yeah? So there has to be attached a judgment to your exam question, yeah? So you could easily draft a case brief, but you can only draft a case brief if there is a judgment. So a case brief is defined as the section of a judicial opinion. So it is basically trying to, not a summary per se, but it's a summary, yeah? But you're dissecting it, but you have to do so critically, yeah? You have to look at, by the way, a case brief will equally have your own opinions at the end. So it contains, but I'm not going to belabor on theory. I'm just doing this to lay basis. It contains a concise written summary of basic components of a court's decision, and really not everything goes into your case brief. A judgment could be 1,000 pages. For example, the BBI Supreme Court judgment. It was too lengthy, yeah? So a case, you could actually you could compress that into a 2-page case brief, and anyone who reads it knows exactly what you're saying. So the purpose of a case brief includes, number one, to understand court's opinion. Now, a court forms an opinion. Really, in litigation, there is no truth and lies. Everybody is speaking the truth. And then ultimately, the court forms an opinion, of course, depending on who's compelling. So if your argument was more compelling, I'm inclined to be moved towards actually believing what you're saying. So a case brief is basically meant to, read and understand the court's opinion and then make a summary of that. Number two, predict the outcome of a case. It could equally help you predict outcome of a case. If you have several case briefs regarding a particular matter, you will easily know how the court is likely to direct its mind. And then number three, come up with arguments for a client's case. If, by the way, you're incapable of sustaining the easiest of arguments in law, if you're not reading cases, you cannot even sustain like setting aside a judgment, you're incapable of sustaining that particular argument if you don't know what the court looks at. So before you even start drafting pleadings, ideally, you read cases, because you need to understand what the court looks at and avoid loopholes which people who've been there, the mistakes they have done, so you're able to avoid them. If you read a lot of case briefs, then easily you're able to understand the loopholes and exactly what is required of you. And equally enables you master new case laws. I think at some point, like right now, you guys might be reading case laws, yeah, with a lot of enthusiasm.
We've lost you, Lydia.
See whether there has been a shift, yeah? Yes, please go on,
Lydia, we lost you.
We lost
are
you for
at
a moment there.
How long? What was I saying? What's the last thing that I said?
About
Case laws.
Oh, I was telling you guys, Vile, you have to keep on reading. I'm not sure which point exactly, but I just recap really fast because I want us to start drafting. And I hope you have your drafting book. So yeah, timetable imetoka, kuna mchezo. So I was trying to explain the purpose of case briefing, why it's important. And I told us it's to understand the court's opinion. Because you see, when you're reading a case, really you think beyond the case, because you critically analyze, yeah, you ask yourself the import of particular sentiments by the court. Number two, you're able to predict outcomes of cases, you're able to come up with arguments of client's case. And I was telling you, you're incapable of sustaining simplest of legal arguments without cases. If you haven't read a case, by the way, God, it's so hard. So case briefing and reading cases basically enables you, yeah, have solid arguments, okay, because you're
Lydia,
able to know what the court is looking for. Yeah, please
we,
go
we,
on.
we we can't see the screen.
Oh Lord, I think what might have happened after, I think my network is actually bad. Let me move 1 minute.
We can see now.
All of us
Okay,
can see it.
We actually were
okay.
seeing it.
Oh, Sawa. Okay, thank you. Okay, so God, can we just start drafting? Let me just go
See
to, you
what?
can read this purpose of case briefing, yeah? So I'm going to scroll down to content, what goes into a case brief, and then we go into an actual case brief as we are drafting. Sindio. So a case brief has at least, well, it has, I want to call them subheadings, yeah, because I think that is what they are. It has at least 7 to 8 subheadings. So number 1 subheading, usually your case brief will have a caption. The topmost part of your case brief is, you will call that a caption because it captures the number of the case, the court where it was filed, and the quorum or the judge who made that particular judgment and the date the judgment was delivered. So there is a caption. And then immediately after your caption, you go to your procedural facts. So this is subheading number 1, procedural facts. And usually before you even start case briefing, you have to have read and understood that case. You're incapable of summarizing a case without having read and understood it first. So the first subheading is procedural facts, and usually procedural facts are in simple. These are events which occurred after the lawsuit had been filed. For example, who is being sued by who? We will say it is Lydia versus Evans. So the details of the parties who instituted this suit and who are they suing will go into your procedural facts. It also includes issues like, is this an appeal? Or have you approached the court on the first instance? For example, if you're case briefing a matter which was from the lower court and now it is at the High Court, then ideally it will be needful for you to mention to your reader that this particular case is actually an appeal emanating from the decision of the lower court in Machakos. So that will equally go into your procedural facts, whether it's an appeal, whether it's actually a fresh suit, has never been filed before. Equally, at the beginning, you will set out the context of the issues that the court will address, not substantively. However, you will mention what generally the court was looking at or the crux, the name of your case. Okay, so we will look at it. It will make a lot of sense when you're looking at an actual case brief, but procedural facts, basically that's it. Who's suing who? Why are we here? Which court are we at? Is it an appeal or not? That's subheading number 1. Subheading number 2 will be your substantive facts. Your substantive facts are also referred to as historical or evidentiary facts. So basically, these are factual bases of the case. Of course, before you get to a point where I am taking you to court, we have a history. Yeah, I sold you land, you didn't pay me, or something, you're my employer, something happened. So there is actually a synopsis, okay, leading to the filing of the case or the factual basis of that case. That is what we call substantive facts. So this is where parties describe the factual story underlying the parties in dispute. Now, a factual story can be very lengthy. It could be a lot of facts. Sometimes all of them might seem relevant, but you have to narrow it down to the most critical fact. In an exam setup, you can't have more than 3 paragraphs, actually more than 2 paragraphs of everything. You can't have more than 2 paragraphs of procedural facts and substantive facts. You have to try it, because remember, it's actually a case brief. So you have to try narrow down your substantive facts to the most essential facts, and not everything goes into your substantive facts. Albeit everything might seem important, you have to pick out the outstanding facts. Like, you know, there are those, a case might rest on so many facts, but there could be a primary fact which the case wouldn't be that case without that fact. So that is what will go into your substantive facts. So that is basically the factual background of your story. And then, okay, just ignore statement of fact. That is basically a substantive fact. And then subheading 3 would be issues. So issues are legal questions. There's a subtopic in civil. It's called framing of issues. Usually, your issues will arise from facts. You'll ask yourself from this because you don't pick issues from the vacuum.
We've lost you again, Lydia.
Centered. I have dragged because I figured out you might have lost me. So issues could be law-centered or they could be fact-centered. Law-centered issues are issues which are legal. For example, is this particular suit res judicata? Is this suit sub judice? Does the plaintiff have locus standi? Those are law-centered issues because they revolve around the law. Or maybe, is this particular suit statute barred? You know? So those are law-centered issues because it's purely law. And then issues could be fact-centered. And if they're fact-centered, basically they are factual. For example, we could ask, when was the agreement for sale signed? That's factual. Okay. Did the plaintiff sign the agreement on the 2nd of July 2022? So it's a fact-centered issue because it has nothing to do with the law. It's basically a fact issue. Okay. So a fact issue is it's a fact. It's really has nothing to do with the law. Yeah. It's a question of yes or no. Yeah. So there are those two types of issues. They could be law-centered, they could be fact-centered in your case brief. Now, a court could either frame its own issues or maybe use issues as filed by the parties. Order 11 of the Civil Procedure Rules, it's actually a mandatory requirement, yeah, before pre-trial that each party puts in a list of issues. The court could use your list of issues as you filed it, or maybe the court decides to flag its own issues and come up with, like, ignore the issues filed by the parties and come up with its own issues. So sometimes you could produce a judgment and the issues are in black and white, okay? So there is issue A, whether FGM Act is unconstitutional, okay? So issues could be in black and white. Sometimes you can't find the issue, like you're struggling to find the issue, but it's actually there. So issues could be framed by the court, or the court could actually decide to use the issues as filed by the parties, or even refine the issues that were filed by the parties and address those issues. Okay, so fact-centered issue or law-centered, legal-centered issues, they could be filed by parties, or the court could actually come up with its own issues. And issues necessarily don't have to be in black and white. Okay, I'll show you what I'm trying to say. But sometimes you could be looking for this, especially for exam. I don't think issues will be in black and white, like issue A, issue B, issue C. They can be all over the place, okay? And then the other part of, this should be part 4 of your case brief, will be the rule of law. The rule of law is derived from Section 5 of the Judicature Act. Section 5 of the Judicature Act has sources of law. So law could be derived from the Constitution, it could be derived from the statute, it could be derived from case laws, it could be common law. So common law is part and parcel. It could be international law because international law is, as long as you've ratified, it's part and parcel of our law. So law could be anything, okay? It could be derived from the Constitution, the statute, case law, international law, as long as it's allowable. So rule of law, you'll just be able to pick it from a judgment. You'll see it. Yeah, the court will be saying Section 2 of the Children's Act provides as follows. And therefore, that was one of the sections relied on by the court in reaching its determination. So rule of law is basically what the court used in reaching its determinations in terms of the law. And then holdings. Holdings, this should be part 5 of your case brief. If a holding is the court's answer to the issue. If you have 5 issues, you will have 5 holdings, because each issue has an answer, and that answer is called a holding. So the number of holdings is dictated by the number of issues. 5 issues, 5 holdings. 3 issues, 3 holdings. Okay, and holdings usually, as you'll notice when you're looking at a case brief, it's a very brief answer, yes or no. Yeah, did the court answer that question in the affirmative or not? And then the other part of your case brief is reasoning. You see, a court forms an opinion. That is what a court does, because it doesn't know who's telling the truth and who's lying. And all of us took oath, okay, when we came for hearing. So a court has to have a reasoning. So a reasoning is meant to justify a holding. For example, if we answered regarding a particular, let's say, whether the FGM Act is unconstitutional. So the court in its holding said, yes, it is unconstitutional. The reasoning is meant to justify that answer, yes, because a court can't just say, yes, the FGM Act is unconstitutional, and then leave it at that. So a court will proceed to justify its holding using a reasoning. So the court would say, for example, here, the reason, of course, not in those words, the reason why we find the FGM Act unconstitutional is because it is actually in dissonance with the societal morals, okay? Or maybe the responsibility of the state to protect its citizenry right of health, because maybe it has some negative health effects. So a reasoning is an explanation as to why we answered a particular issue in a particular manner. If we said yes, then we proceed and tell you why we said yes. If we said no, it's not unconstitutional, then we will justify maybe by saying that, you know what, it's not unconstitutional because that's actually a very private affair. Okay, people have the right to, they have right of autonomy to do whatever they wish. Okay, so basically a reasoning is a justification of the holding. Okay, so it's a justification of why the court has said yes or no regarding a particular issue. And reasoning or rationale is the heart of a case brief, because basically that's why you see how the court, the thinking of the court, you're able to pick the court brains from its reasoning or its rationale. Justification could be anything. It can be social justification. A court could say FGM is illegal and unconstitutional because, you know what, it's actually in dissonance with our societal morals. It could be a political justification, because we believe if we actually told you guys to go back to the ballot, you'll start throwing stones, yeah, and it'll be an ungovernable state. It could be a legal justification because the law provides, you know. So a court forms an opinion. A court could give the most asinine reasoning, but reasoning nonetheless, because its holding has to be justified one way or the other. Okay, and then the last part of our case brief, okay, not the last, but last, is a judgment. So judgment is the final order. It's the final order of the court after resolving all these issues, after giving us its issues, its holdings, and now trying to justify those holdings, we ultimately get a judgment. And of course, as you're reading the court reasoning, most often than not, you can actually tell where we are headed. Yeah, you can tell that the court is yeah, we'll say that we'll throw the BVI out of the window, because easily the reasoning will dictate the final order. So judgment is your final order. Now the court says, you know, the FGM Act is illegal, it's unconstitutional. And a court indicates its formal action in the judgment. So it indicates the formal action to be taken. For example, it could dictate that a particular act, be amended to a particular extent. So it dictates exactly what to be done in its judgment. Okay, so it concludes your case brief, and it's very brief because just shows how the court disposed of the case entirely. So that's the last part of your case brief in an exam. Don't waste time writing other things. Andika hadi judgment, that will be sufficient. However, sometimes a case brief can have your opinion. Yeah, you could have your opinion about a particular aspect of that case or that judgment. Could have an obiter dictum, could have a dissenting opinion where there is a majority decision and someone else dissented, or it could have parties arguments, but really don't do it you don't have the time. So your last part, I imagine, in your exam for your case brief will be judgment. So without much ado, let's look at a case brief. I have one here. Now, really, we are not able to go through the entire judgment, but I believe because you guys are brilliant, you'll be able to contextualize, but I'll give you brief facts of what was happening here, okay? But you can pick it from the procedural history. Anyway, so your case brief will be case brief, okay? So your title will be case. As I told you, this unit is so petty. CLE doesn't have a marking scheme. However, this unit does. These other units, conveyancing, commercial, they just have expectations. This particular unit has a marking scheme, like correct answer, wrong answer. The minute you miss the title, your exam setter seated by the beach, sipping fine cognac, you didn't write the title here. They'll be so angry, but they won't even, they'll mark, but they'll be feeling some type of way, yeah? So make sure your case brief has a title. Any document in these units has a name, so it has to have a title. If it's a demand letter, it has, anyway, we will get there. But a case brief, you have to write case brief on top, okay? And then consequently, after doing so, it has citation. These are your parties because all cases have parties. So our parties here are Dr. Tatu Kamau versus the AG and two others.
We can't hear you.
Just copy, you will ideally copy paste how it looks like. The citation, you don't change anything. And then the case number, this was petition number 244 of 2019. And then the date this decision was made, it's 17th of March 2021. And then the quorum was Achode, Kimondo, and Muigai Justice. And then High Court of Kenya, Milimani.
We can't see what you're projecting.
What?
We can't see what you're projecting, and we lost you for a minute back there.
Okay.
Yes.
At what point
It's
did
okay
you
now.
lose me? I was telling you about citation. Okay, maybe. Okay, Sawa, we can take that again. I'll get my network sorted. Yeah, I will. I think it's fluctuating a lot. So we've said it has to have a title, and then it has to have citation. Okay, the parties in the case. So we said the citation, you just copy paste the way it is, yeah, in the paper, because you have a copy of the judgment with you. So ideally, you will just copy the details, and then has a case number. This was petition 244 of 2019, and then date of the decision, 17th March 2021. And then quorum is basically who was sitting, because these are 3 judge bench. And then court, if it's 1 judge, you just write their name there. And then the court was at the High Court of Kenya at Milimani. And then the division was constitution and human rights. I'm not sure whether that's correct or it's constitutional and human rights. You can check, but I highly doubt it's constitution and human rights. That sounds something sounds off. Okay. nonetheless, that's how we call this a caption. It just basically shows the case number, the case details. What case is this? Because a case has to have a number, has to have parties, and of course the date of the judgment. Okay. Now, the first part of your case brief is your procedural history. And of course, we've said that now, if I were you, I would number them as A, B, to enhance coherent appreciation of your work. So you will start with procedural history and you write it up there, procedural history, okay? And then it has to be like kidogo. Don't put a lot of facts because you don't have time. After reading that judgment and you've already appreciated the facts, then it will be so easy for you to come up with a proper procedural history. You remember that procedural history is basically where was this, like, is this an appeal? Who is suing who? And do you have any interested parties? Do you have a missus? Like, who are the parties? For example, in this one, it was Dr. Tatu Kamau, who's a medical doctor, who filed the petition of the High Court in Machakos. And then consequently, the DPP sought leave for the court to be for them to be enjoined, and then the High Court of Machakos equally granted leave to other 10 interested parties to join and 2 amices to join. Of course, all these details you will easily pick them from the case because they're there in black and white. And then consequently, and then it says there was a single judge handling the matter. However, the CJ empaneled a bench of 3 to handle and determine this particular matter. So that would be your first part, which will be your first paragraphs in the judgment. It wouldn't be so hard for you to pick these facts because if you know what goes into a procedural history, then it becomes easy for you to know where those facts are in the judgment. Yeah. So you can handpick. This is not a big task. I'll show you where the task is. So procedural history will be there in black and white, usually the first paragraphs of your judgment. And then part B will be your substantive history. Substantive history, as you remember, we said that these are factual bases, okay? Where is the petitioner coming from? What gives her the right to actually institute the suit? So you explain briefly, of course, again, picking it from the judgment, and don't paraphrase word for word how it is in the judgment. You have to be very cautious because ideally, if you do it, the examiner will see that's what you have done, okay? So you have to have read and understood, as I told you. So your substantive history, you will be basically telling us what are the factual bases and what gives the petitioner the right to actually sue, okay? So in this instance, the petitioner was aggrieved by some of the provision of the FGM Act, okay? And it was her assertion that the impugned act, limits women's choice and rights. She proceeded to question constitutionality of sections, all these sections, and she actually claimed these sections, they contravene some articles of the Constitution. She equally said that in her view, an adult woman should freely choose whether to undergo FGM under the hand of a trained medical practitioner or not. She equally said she believed that the FGM Act is an imperialist imposition from foreign culture that holds a different set of beliefs and norms. So basically, this is where Dr. Tatu was coming from because, you know, these are her factual basis. Like, she's aggrieved by this particular act because she has so many unanswered questions, and that is where she's actually filed this particular petition in order to address some of these issues and concerns that she has. Okay, so your factual basis, by the way, you have to read and understand that judgment. Otherwise, you might misinterpret, especially for constitutional petitions. You might misinterpret what the facts are. So you read it, understand it, and then in your own words, you put that down. Okay. We equally said in your substantive fact, you could briefly state what the petitioner, the plaintiff, or whomever approached court is seeking. Okay. So we, in this particular case brief, those prayers are summarized briefly, very, very briefly. Sometimes you really don't even, you could actually mention one where you don't have time to write all these. So you could say the petition therefore sought for you could say for a declaration, and then you say amongst other orders, and then that's it. You don't need to, there could be so many, you don't have time to write all of them. So you could just say the first one, because usually the first prayer is the primary one, and then you say she sought for that prayer amongst other orders, and that's it. Okay, you really don't need to repeat all the prayers as they are in the judgment. All right, and then so that's it for part B of your case brief. You just tell us where you're coming from in terms of your factual basis. And then part C, your issues. So your issues, remember, they could, number one, they can be concentrated in one paragraph. You can read a judgment where the issues are in one paragraph. You can easily pick them. Sometimes you might find that, but then I think we'll have to look for this judgment. Yeah, you could find a judgment where the issues are like you can't see, but they're actually meant to be there. So it's up to you to look at what was the court addressing in terms of questions. Okay, so in this particular judgment, the issues were in one paragraph. The court had actually listed them out, and that's a good judgment. But sometimes a judgment might have, okay, I'll show you one, and then you'll understand what I'm trying to say. But don't expect the issues are always there in black and white. Sometimes they could be all over. They're all over. Yeah, but I'll show you what I'm trying to say. So for issues, you will say the following issues were listed for determination, and then you proceed to state the first issue. Each issue has to have a question mark. You can't just say, you can't put an issue without a question mark, because it's a question actually, which the court is going to answer. So the first issue is whether Section 2.5 of the Impugned Act, the FGM Act, these sections are unconstitutional. Okay, so you put question marks on each of the issue, question marks on each of the issue. So you would, if you're lucky enough, you can easily see the issues. Then you just paste those issues into your paper as you put question marks. Yeah, who should pay the cost? You put question mark, because that was equally an issue for determination. Okay, and then you'll remember the other part was, after you list your issues, you're not telling us anything, stories, you just list the issues and you move on. Okay, so we go to part D. Part D was our rule of law. And you'll remember, we say that you can derive it from anywhere, from the Constitution, from treaties. You could pick that from statutes, from common law. So in this particular case, this is what the court relied upon, the Constitution. Now, you see, the court could have relied on so many articles of the Constitution. And again, they could be littered all over the judgment. So you'll pick all those articles and put them below the subheading Constitution. Yeah. So in that entire judgment, yeah, the court found articles 2, 10, 11, 55 relevant for determination of the issues raised in the petition. So you collate all the articles that have been relied upon by the court, and then you put them here, all of them. So you will maybe using a pencil underline all articles, all of them, and then in your answer booklet you will say the court in determining the issues it relied on, you check Article 2, Article 13, Article 50 of the Constitution. That's it. And then the court in this particular matter equally relied on treaties and conventions. And at this point, you can know it. No one is explaining what article provides for what here. So you basically tell us these are the articles the court relied upon. And then for treaties and conventions equally, the court relied on these treaties and conventions, because remember, should be Article 2, Clause 6. But I know you guys say Article 2, subarticle 6. There is nothing like subarticle in the Constitution. They're called clauses. So treaties and conventions, the court relied on these articles of the UDHR, and then Article 3 of the International Covenant on it. Like you consolidate them into, you bring them under all the articles and conventions that the court relied upon. You put all of them under treaties and conventions, under the subheading treaties and conventions. Okay, so you just you don't even think. Yeah, so your primary objective is to underline those treaties and then paste them into your paper without analyzing what they provide for. And then the court in that matter equally relied relied upon case laws. So it says the court relied on the following 7 cases whilst interpreting the constitution. So the court relied on these cases. Again, you don't think they are there. They will be in the judgment. I think we'll finish this and then we go to that judgment. I show you where everything was coming from, right? So those particular justices of the High Court relied upon these cases in determining the issue, because remember, equally, common law is part and parcel of our law. So common law includes the decisions which are binding and persuasive upon the court. So the court used those cases, and then after, so you're going to, in your rule of law, you list all the sources of law that were relied upon by the court. And then, of course, briefly, you will just state the articles, you will state the sections. I think this court didn't rely on any actual parliament. Okay, there is none here, so presumably didn't. And then after listing your rule of law, you go to your holding. Okay. Wait, just a minute. Just give me a quick minute. This should be, yeah, after your rule of law, this rule of law should come before. So let me tell you a story about this case brief. This case brief was done by my farm leader when I was at KSL, yeah. And I remember we used to fight it about it every single time. Anyway, so it's your rule of law. It's your rule of law. Just a minute. Just give me a minute. I undo that. Yeah. That's okay. Okay. So your issues after your rule of law, which you're not going to discuss, you just list the laws the court relied upon. You go to your issues. So your issues, you list your issues and then you go to your holding. So your holding will be answering your issues, and it is wise. Well, you don't have the benefit of doing that, but ideally, it's like you're copy pasting all your issues into your holding, yeah? Because remember, the number of your issues will determine the number of your holdings, yeah? So this is what you will do. You paste all of them. You paste all your, let me just zoom out. God, it would make sense. So you paste all your issues, your 6 issues, into your holding, because you're supposed to have an answer for all your issues. And your holding has those answers because you said that holdings are court answers to the issues. Anyway, so on your first issue, for example, yeah, we said on whether you could briefly show which issue you're addressing. This was on whether sections 2, 5, 21 of the FGM Act are unconstitutional. So in this particular case, the court noted that the sections are not unconstitutional. So this was the court answer regarding that particular issue, yeah? So you're answering each of the issues. If you have 6 issues, you're going to have a holding for each of those 6 issues. So here the court said, no, these particular sections are not unconstitutional. However, the court noted that section 19 required to be amended in order to avoid ambiguity. And then on the other issue, the second issue, the court, you briefly state what the issue was. Let's go to that issue. The second issue was whether the second respondent board was illegally created and whether its mandate infringes on the rights of women as enshrined in the Constitution. So regarding that issue, it was held that the board was properly created and its functions are in conformity with the FGM and the Constitution. Yeah, and the court was unable to impeach the offense created by those particular sections as urged by the petitioner. So this particular, the petitioner wanted this particular act, some sections to be declared unconstitutional, but the court, of course, was not agreeing with her. Yeah. So in the first issue, the court says, no, these particular sections are not unconstitutional. Second issue, the court answers that actually the board was properly created. And then on the third issue, if you go to the third issue says whether FGM is a harmful cultural practice. So in answering that particular issue, the court held that actually FGM is a harmful cultural practice. So the court answered that question in the affirmative, because the court says it has both short-term and long-term negative effects on the victims. And these effects are physical, psychological, emotional, social, so many problems. And sometimes they can be very fatal. Yeah. So the court is answering, you can already tell where the court is headed with this petition. And then on the other issue, the fourth issue was whether the rights of women to uphold and respect their culture and identity has been violated by the Act. In answering that question, the court said that no one can choose to undergo a harmful practice as part of their culture. That is what the court said. Okay. Of course, sometimes the court will try to be vague deliberately, yeah, for example, in that issue. And then on the other issue, the court asks whether the petitioner is entitled to relief sought. And then on that particular issue, the court held that the amended petition was devoid of any merit and was actually dismissed. And then lastly, on the other issue, who will bear the cost? The court held that since the amended petition raised constitutional issues in public interest, each party should bear its own cost. So that is how you will ideally do your holdings. Very briefly, you just, in few words, yeah, restate the issue, in a very coherent manner, yeah, from issue number 1. This is what the court held. Issue number 2, this is what the court stated. Issue number 3, this is what the court stated. And briefly. And then for you to find this holding, it's not easy for you to find a holding. It might seem easy because they're here, they're written, but you have to have read that judgment. You'll have to read it at least 2 times, yeah, for you to be able to pick out the holdings, what the court was actually saying in regards to every particular issue. And the judgment could be lengthy. It could be a 20-page document, but I don't think it can be that lengthy, but can be a lengthy judgment. So you have to read it for you to appreciate what the court was saying on each of the issues, but that's how you will ideally do your holdings, eh? You briefly say on this particular issue, the court noted that this is the position. On the second issue, the court held that the board was actually properly in office. And then on the other part of your case brief was the rationale or the reasoning. This is where you answer your whole, you explain why the court said, for example, number 1, that the sections are not unconstitutional, why the court said that the board was actually properly created, why the court says FGM is a harmful cultural practice. Now, your rationale, you're going to rationalize every issue. So again, you would copy paste all your issues here, all the issues that you have, you would copy paste them. And then you proceed and provide a reasoning for each of the issue, because usually the court has a reasoning for all its issues, yeah, and why it answered particular issues in a particular manner. So in your rationale, you start with issue number 1. Issue number 1 was, God, this should have a question mark because it's a question. So on issue number 1, you will proceed and explain why. Of course, you'll pick that from the judge. Okay, albeit not easy. But then before that paper, make sure you write at least 2 case briefs. You pick a judgment and then you attempt writing a case brief, yeah? Because you can see it has a lot of parts and you have to have read that judgment at least, I don't think one time will enable you appreciate everything that's going on there, unless you've read it before, yeah? Otherwise, you have to read that judgment at least 2 times, okay? So your rationale, you start with issue number 1, because there has to be a reasoning for each of the issues. So you will start with issue number 1. The reasoning of the court in this issue was that there is a rebuttable presumption of constitutionality of statutes. This statute is not spelled well. That's how you spell statute. Really? I don't think so. Statute. I think it's like that. Lord. Okay, the evidential burden as per section 107 of the Evidence Act fell squarely on the petitioner to prove otherwise. And then the court ultimately says the petitioner had not discharged the evidential burden of proof. And then the court relied on these particular cases to back up its reasoning. Because remember, reasoning can be backed up by the law. You can think in a particular manner because the law allows you to. Okay, so in that particular this particular issue, the court reasoned using the law. The court said section 107 does not allow you the petitioner, yeah, you have the burden of proving your petition. However, the petitioner failed in total, yeah, to discharge that particular burden. So you would, and then it used case laws. So that was the justification section 107 and some case laws as well. On issue number 2, God, this should be a question mark. My family leaders, I don't want to digress. A story for another day. So whether the board was illegally created, the court noted that the petition did not plead with specificity the elements and functions that are unconstitutional. And again, the court relied on Anarita Karemi Njeru. This is a very, very good case for constitutional petitions because you have to be very precise, yeah, where you're alleging that a particular body is unconstitutional or act is unconstitutional. You have to do so with a lot of certainty. So the court used Anarita Karemi Njeru, a pretty old case, in stating or concluding or reasoning, yeah, that you didn't show us how this particular body is unconstitutional. So it should actually be shorter than this. You could have like one sentence. Don't say a lot of things, or 2 sentences. Don't say a lot of things. Yeah. And then issue number 3, the court proceeds to give explanation as to why this was answered in the affirmative, because the court said that FGM is a harmful cultural practice. And then the court in this particular issue noted that those who undergo the cut are involved in a cycle of pressure from family, clan, and community. And the court then says that they suffer serious health complications, while those who refuse to undergo it suffer consequences of stigma. And then the court supported its reasoning using this particular case. If you read this particular part 1, you'll see that, Akazori, look, the court was using social justification, you'll be stigmatized because of the community. You actually undergo the cut because of family, clan, and community. So the court can actually use a societal approach, yeah, in its reasoning. The court can actually say, we are a society that is big on morals, but sometimes using whose yardstick, because it's neither here nor is it there. But the court was using some sort of society morality justification to show that this particular cultural practice is very harmful, yeah, for the reasons it gives. It says, vulnerable women and children, due to social pressure, may be subjected to the practice without their consent. And then the court gives this particular case to the same regard, continues explaining why actually this is not a good practice. And then another issue the court analyzes, tells us why we think that FGM violates the right. Okay, so in answering this question, whether enactment of FGM violates the right to women, the court said that it is the duty of the state to actually protect women and basically citizens, yeah. And then it says, albeit you have the right to do that, we have the right as a state to actually prevent you from doing it, because it is our obligation, yeah, constitutional mandate, to make sure we uphold your right to health, okay? And then ultimately judgment, that's the last part in your exam, unless the examiner asks you to maybe have a dissecting, sometimes where you have but if you, well, that could be I don't think you might have a lengthy judgment, for example, purposes, because of time, yeah? So my assumption is this will be your last part of your case brief, judgment. So judgment is the final orders. This is where you put your final orders. Firstly, the amended petition in this case was found to be devoid of any merit and it was dismissed. And secondly, the AG was ordered to forward proposals to the National Assembly to consider amendment of Section 19 of the FGM Act with a view of prohibiting all harmful practices of FGM as set out in that judgment. And finally, the court stated that each party was going to bear their own cost. So that is basically it for your exam case brief. Commentary on judgment, really, well, you don't just take judgments because they're there. Yeah, sometimes you can criticize them. You could tell us what your opinion is, but basically, really not needed for your exam purposes. That will be it for your exam. I'm not sure whether we have any questions, or could you guys, maybe there's an exam question which has a case brief. Yeah, I think it's 2018. I'll give it to you before we finish. Yeah, you could attempt that case brief or any other judgment for that matter. This case brief was fairly easy because number one, issues were concentrated in one paragraph. So it was so easy for you to pick the issues. It was a really good judgment. Reasoning was there. Sometimes you'll struggle to pick the court reasoning. Yeah, especially where it's not a really good judgment, you might struggle to pick the reasoning. You're not seeing the holdings. Yeah, but it's actually there. So it's I think it will be easy in an exam because my thinking is, an examiner wouldn't want you to struggle, yeah, getting a holding. So they might pick a really easy judgment. And again, I don't think CLE CLE wants to print so many pages because that will mean resources. So this is the judgment that we've just looked at. Well, it's quite lengthy. Actually, this is a summary of the judgment. It's because usually Kenya law will do summary. This is a summary of the judgment. I think the entire judgment should have been at least 30 pages or 25 to 30. I don't quite remember. So you will actually attempt that particular case brief. Yeah, I'll be happy to look at it and tell you what I think about it. Do you have any questions? Let me see whether I can get that exam paper. Because I have my hard copy. Past papers here. I could peruse quickly, see whether I can get it. But I want us to discuss policies. So most importantly, let me show you how I used to remember the parts of a case brief, because right now it's all about your capacity to remember. I was telling you guys, no one is testing your how smart you are. No one really cares about how smart you are. So it's about how much can you remember, because you might actually read that entire thing, and then on Thursday morning, unafika huko get umbuki kitu. It actually happened. So I'll show you how to remember a case brief using an acronym that I used to use. You could use that. Because if you miss a particular, you see, it's a format. A case brief has a format. So if you miss the format, that it means you might miss a lot of marks. Okay, so you have to remember it as follows. I'll just do it and then I'll show you the acronym. So it has procedural facts and then it has substantive facts, and then it has issues. I remember when we were doing that case brief, Lord, my family leader was called Wanyonyi. Now he never used to attend meetings. And then he'll delegate his work to someone. Actually, I remember one time we were having an online meeting, like an online class, yeah, and he was smoking a cigarette. I think that thing actually was trending. So up to this date, I remind him about. I think we did that case brief for a month. Those were tough times. Okay, so these are parts of your case brief. It's just 7 parts. So how you make sure you remember it, you can use my acronym, or you could just do your own acronym, whatever works for you. It's allowable as long as you can remember. Okay, and then immediately after you forget. Yeah. Let me show you. Really, it doesn't make any sense. It's not even a word. Yeah, but it worked nonetheless, So because it's all about, can you remember the parts of a case brief? So this is it. Yeah. Now I used to read it as, it's a very personal case. It's a very personal acronym. I'm not sure that makes sense to you. I used to read it as PISA, Human Rights Junior I know, but you could have something like that to enable you remember anything, whatever works for you, Bana. Because after that day, no one cares whether you crammed, whether you had an acronym, as long as the content is on the paper. All right. So whatever works for you, you could do it. However, this is what I used to. This is what I used. I found it quite easy because it's just P and the word sir, and then human rights, and then J at the end. But whatever works for you. Sindio. So anyway, so we leave it at that. We discuss a policy now. So remember the part of a case brief. Now, what will happen, for example, with my farm leader, you know, I'm not even sure where he went, but I'll look for him. But weirdly, he passed really well. You see those guys that don't even go to class. So if maybe you miss some parts, or maybe you have your, let's say, your substantive facts coming before your procedural facts like this, it means you're not going to get a mark, because as I've told you, in this unit, you have to remember the format. So I don't want to dilute it. Let's discuss policies. There's a really good policy by LSK. I'm not sure whether you guys had a chance to look at it. The last time we were here, I asked you guys to look at it. So let me get policy, and then we discuss policy, and then after discussing policy, I'm going to give you a question on case brief. Just make sure you remind me. You remind us before we finish the class. Okay, so let me share the slides on policy. We briefly discuss what a policy is, and then we draft a policy, and then we draft a cabinet memorandum. So a policy is basically a document that is meant to show people how to behave, okay? Like to dictate how guys are going to carry themselves. You see, we as human race, we really have to be told what exactly to do. So a policy is meant to achieve that particular purpose, okay? So a policy might precede the law. Sometimes actually a policy will become the law. Okay, so most of our bills and acts of parliament, they were at one time a policy. So a policy is basically will revolve around the idea of regulating behavior. Yeah, how are you going to act? Where are you going to go? So a policy is defined as a course or a principle of action adopted or proposed by the government, party, business, or individual. Well, you don't have to remember a policy in these exact words. Yeah. So this is basically a document that guides people on exactly what to do. For example, we could have a policy on management of water resources. We could have a policy on sexual harassment at the workplace. We could have a work culture policy, you know. We could have a retirement policy. So it governs exactly what's to be done at what point. In the context of legislation, a policy is a document which outlines what a government or an individual aims to achieve for society. So it might outline, it could be a policy that outlines exactly how the government is going to curb climate change. Yeah, it could be a policy dictating how the policy is the government is going to ensure that it meets its objective regarding affordable housing. So it's a document which it actually delegates responsibilities to various people, and it could have objectives, it could have timelines on when are we going to have achieved this particular objective. All policies will start as ideas, and then they'll be put on paper. Okay, the Constitution recognizes instances the necessity to, number one, formulate, debate, approve policies. So a policy in terms of legislation doesn't become a policy unless it is debated upon. The public participate. You remember that issue of public participation, yeah? But it has to be both qualitative and quantitative, yeah? So you have to explain to everybody because the policy might be affecting the larger population. So your member of parliament has to debate and of course on your behalf table your concerns at the parliament. So a policy has to be debated and then consequently approved. The constitution recognizes the need for all arms of government to engage the public in formulation of policies. Albeit it's not an act of parliament, the distinction between a policy and an act of parliament is that an act of parliament has permanency. A policy doesn't have permanency. In fact, a policy is not law per se, yeah, as compared to an act of parliament. An act of parliament has some sort of permanency and equally has some penal provisions. A policy might not have any penal provisions. If you decide to maybe do something which is actually flies on the face of the policy, what's going to happen to you? Sometimes a policy might not have any penal provisions at all. Okay, so who initiates a policy? Anyone can initiate a policy, yeah? An individual at a workplace, your member of parliament, your senator, your MCA, anyone could initiate a policy. Okay, I want us to discuss the process of policy making. I'll share these slides with you because of time. Cindy, we draft a policy. So I'll scroll down. It's actually, the constitution is really big on public participation, yeah, when making law, including policies and legislations. Yeah, so there's some sections and some articles of the constitution, yeah, when making a policy. So I'm just going to scroll down to the process, yeah, to policy formulation process. So stage number 1, when you want to pass or make a policy, is policy initiation. So policy initiation is a function of all stakeholders, all relevant stakeholders. They include government ministries, you as a citizen, institutions, departments, agencies. And once the proponent generates the idea, then they'll inform the relevant national or county executive concerned. So of course, if it's your MCA, they will inform the county executive that they have a particular idea, maybe regarding a particular, let's say, a particular way to distribute crop to farmers, yeah? But the idea has to be floated to the national or county government by the proponent. And then consequently, the relevant department will formulate policy guidelines, which will be reduced into writing for discussion purposes. And then stage number 2, that particular department, MDA means ministries, departments, or agencies, yeah? So the respective department, so this stage number 2, after policy initiation, basically the idea being put down on paper and being floated to the relevant national county executive. So stage number 2 includes research, because for you to know, a policy can't be in dissonance with constitutional provision or the statute. So you research. You can carry out study visits with or within or outside the republic. Of course, your variable politicians will go to benchmark in Maldives, in South Africa, in China, in Japan, but you can actually do study visits within or the outside the country. So because you want to learn the best practices from the national or international level. And then you might also require to get expert opinion, especially in a gray area. For example, in this country, let's say issues to do with registration of those organizations that ideally we feel like the names are offensive, it's not allowable by the society. And then we want to come up with a way of registering such NGOs or a policy to actually assess whether the names are suitable, they're in consonance with our societal norms. So you might need to seek expert opinions. And then the national, the county entity will work closely with the state and agencies which are tasked with an obligation. If you're dealing with a policy which might affect the education, then you might need to work with the education ministry, yeah, consult them. And then consequently, you'll have a task force to discuss the policy and any consultative machineries that may be constituted for purposes of discussing the policy and the contents that will go into your policy, after researching. So stage 2 is majorly researching. Researching is, it's amorphous. It cuts across various areas. Study visit, expert opinion, task force, consultative machineries. And then stage number 3 is negotiation and public participation. Of course, the most important stage. So at this particular stage, the substantive contents of the draft policy framework are debated and negotiated, because at this point you have a draft policy. So the draft policy will be debated, it will be negotiated by political parties, by the public, by NGOs, by interest groups. Sometimes guys will be asked to submit their memoranda, yeah, regarding a particular intended policy. What you think? And then discussion documents are prepared by the department responsible on the policy or the law to facilitate a debate, feedback, or comments. So you remember, I'm not sure whether you might remember. I remember vividly because it was televised, and I remember the issue of public participation being both qualitative, quantitative. So if you give people a platform to respond to a particular policy, then you have to give them a chance to actually explain the content of their response. Yeah. So if I send my memoranda to you for consideration regarding a policy, then I have the right to actually address you regarding the content of my memoranda and clarify any issues. Stakeholder participation may equally be done through parliamentary committees, hearings, setting up meetings with cabinet secretary. So basically negotiations with everyone that is relevant, and then you could equally ask guys to publish extracts in newspaper articles, depending on what they think, submit written opinions, memorandas, and then consequently they'll be considered. More often than not, in this country, including LSK, LSK will ask you to do a memoranda and then submit to it, because LSK intends to maybe address a particular committee regarding this particular bill, regarding a policy, and then it never actually sees the light of the day, you know? So you'll submit your memorandas, you'll do your write-ups, but no one ever looks at them. I think more often than not, they're actually political, they're political agendas. So if there is a policy which has to be passed, it does not matter whether your memoranda is from here to Mesopotamia, it will be passed. However, nonetheless, the public has to participate actively, qualitatively, and quantitatively. And then stage number 5 is finalization of the policy. So after everybody has, submitted what they think they should, ultimately the policy will be finalized. So issues will be crystallized, and if need be, if maybe there was a public uproar regarding a particular point in the policy, you can redraft it. And then consequently, the bill will be taken to the cabinet or the county executive for approval. Of course, if it was a national policy, it will be taken to the relevant cabinet. And then if it was a county policy, the county executive, and for purposes of approving it. So they'll give it one final look, and then consequently,
Lydia,
they'll just approve there.
Lydia,
Yes, please. Yes, please.
Yes, which was stage number 4? I don't think we got from stage 3 to 5.
You got stage?
What stage 4? Stage 4.
Stage 4. Just a minute.
You repeated 5 twice.
Oh, you've repeated 5 twice. So this is 4. Stage 5 is 4, and then this becomes stage 5. Okay, so that finalization is polishing, editing it, incorporating opinions, and then deleting what needs to be deleted or amending as appropriate, depending on the comments that you got during public participation. So our 5 is 3. Stage 5 is, stage 5 is 4. And then this stage, cabinet or county, the final stage, this is our stage 5. Okay, I'm sorry about that. So it is approved by the executive, by the county executive or the cabinet, depending on whether it was a national policy or a county policy. And then ultimately, this is basically an extension, the same stage, yeah, approval by the relevant body. So after it has been approved, then of course the members of the public, it is assented to, and then the members of the public are informed through gazettement that a particular policy is now in force. Okay, so that is what will happen. Lastly, it will be assented to, and then after being assented to, then ideally it is published, and then it becomes not, I don't want to say law, but it becomes, it's actually from that point we start implementing it. So if we were supposed to do a particular thing under that particular policy, then we start doing it. Yeah, so it is endorsed using the national seal or the county seal, and then that's it. That's how we assent. Okay, so that's how you formulate a policy. There's some other part of a policy which you haven't discussed. Part of a policy, maybe we could discuss parts of a policy and then we discuss a policy. Yeah, we look at an actual policy, and I hope you're noting those. These things are easy. It's all about, but then sometimes that marker will not even read the content of your work because because they want to finish. Yeah, but if you've arranged your work, you understand the format, they might actually just mark and assume that you know and give you a 10 out of 10. So please remember to look at public participation, or maybe we could equally look at it. So I want us to discuss parts of your policy or features of your policy. Basically, these are parts of the policy. So what goes into your policy? It will have a title. It has to have a title. It's up to you to come up with a title of the policy. It could be, you have to be a little bit creative. Just like, you remember when you were doing titles for bills, so it has to have a name. It could be, but I don't have any idea, but you have to have a name. Given fact, you could choose a suitable name, which is not too lengthy, and then it has to be clear what your bill is about. Okay, so your bill has an introduction. It has situational analysis. So basically, this is the status quo, yeah, and then sets out the challenges or problems. And then it has analysis of the existing legal framework. And then it has strategies for implementation. And then it has actors or shareholders. Basically, you remember I told us that it has to have responsibilities, because ultimately for you to be able to meet the objectives, someone has to do something in that policy. So it has the roles, responsibilities of various actors or stakeholders. Okay, and then it has targeted audience, or to whom does it apply? Yeah, does it apply to a particular group of people? Does it apply to all of us, like Kenyan citizen? And what's our role? And then it has monitoring and evaluation mechanism, because for you to know whether you're meeting the objectives in your policy, you have to actually have evaluating mechanism. Yeah, you could use data maybe on a monthly basis. You could use questionnaire to see whether you're actually doing what the the policy intended to. It could have review measures. You could review it annually. You could review it every 3 months. And then when you're reviewing it, you could be asking yourself, what are we not doing right? You see, on paper, a policy could look really good. And then the minute you try to implement it, it is met with a lot of hostility. So you're left in the cold with your policy, So review measures will enable you to see how far have we gone in terms of achieving our objectives. Do we really need to maybe, do a lot more of educating the public regarding this policy, or do we need more budgetary allocation for us to meet the objectives as laid out in the policy. So review enables you to actually, like, shows you where you're coming from, what you've done so far, and whether you're actually doing anything. And then it has conclusion and way forward. It could have a conclusion and way forward on how to approach issues. It could have a provision of a legal instrument for its operationalization. Sometimes a bill could actually recommend the need for an act of parliament. Yeah. So the policy could, well, it could actually work, but ultimately it might highlight the need for this to become an act of parliament for reasons 1, 2. Yeah. So your in your policy you could illustrate, do we need any legal instrument, maybe for purposes of making sure that this policy ultimately works? So I have a policy here. A policy could be longer than this, yeah, but this could be your most critical aspect in a policy. Yeah. So there is a policy that I have. This policy is an LSK draft policy. However, it's a really good policy. I consider it a really good policy because it has all the salient parts of a policy, and then it's a really comprehensive policy. It's good for your revision. So this, of course, you won't have a logo in your policy. Yeah, so your policy has to have a name. So your name could be anything depending on the facts given. Yeah. There is an exam past paper which I'll show you, and then you will tell me what your title would have been. So the title in this policy is Law Society of Kenya Draft Sexual Harassment and Bullying Policy. It could be Occupational Safety Policy. It could be Sexual Harassment and Bullying at Workplace Policy. Can be any policy. So your policy has to have the year when it was formulated. This was 2019. Okay. And then your policy, okay, in an exam, you don't have time for table of contents, yeah? But ideally, it should have a table of contents, but for exam purposes, because that is what we are focusing on, you will go right into, after your title, okay, let's say sexual harassment and bullying policy, you will go right into, you could have definitions. Just define two, okay, in your policy, usually definitions for any legislative piece, it has to be a word that you've used more than 2 times. So you can't define, you can't just define things because you want to define them. For example, you can't define harassment if you've used it once in your work. So you'll define a word if you've used it more than 2 times. Yeah. So to show the examiner your very good grasp of drafting policies, you could have 2 definitions. You can define maybe sexual harassment, and you could equally define bullying. So this has defined a reporting authority. That's the only definition in this policy. Just ignore executive summary. So immediately, okay, so this is how it would flow. You will have your title, and then after your title, you will write, you see where there is 2. Upper before you write 2, it will be 1, and then you write definitions. So your definition wouldn't be up there. So your definition will be here. And then a statement of policy basically captures the entire essence of your policy. If you read this particular statement of policy, it basically shows you why it was needful to have this policy. It says it's because LSK has received a lot of complaints regarding sexual incidences at the workplace. That is why there was need for this policy. But then there was a time sexual harassment was so prevalent in law firms, like really bad. Yeah. So it was needful to have this policy because LSK used to receive complaints on a weekly basis regarding sexual harassment at the law firms. So that is basically it. What's the essence of your policy? That's the statement of policy. And then it could have scope. Scope basically means to whom does this policy apply to? Of course, you can't dispense with scope because it's it's needful to show to whom does it apply to. Does it apply to all law firms, or does it apply to every single advocate, atakama you're unemployed, despite where you are? To whom does it apply to? So this policy applies to every level and extends to partners, employees, extends to pupils and students of law firms, and equally the LSK, and applies to in-house counsel, applies to physical offices, extends beyond the workplace, including conferences, training sessions. So this particular policy only applies to, well, to advocates, really, not advocates, but anyone working in a law firm. That's it. Anyone working in a law firm, or anyone who's an in-house counsel. It equally extends to if we are in a conference, okay? We are in travel, social functions, including travel. I remember there's someone I know, so their pupil master used to they used to go to out of court stations, and then when they finish court, of course, it's very late in the night, and maybe it's a 2-day matter. So they'll go to a hotel, and then this person, he's only booked one room, okay? So they are very concerned. Why are they doing that? So it includes when they travel, you have to actually make sure there is no sexual harassment. So your definition section will come as the first thing. Don't put definitions there. Put definitions as the first thing. But this particular act goes on definition is there. Gives examples of what sexual harassment is, and then it has bullying. So it has several parts, but this is basically the substance of your policy. And then remember, you have to have a legal framework in your policy. Your policy has to be in consonance with the subsisting laws. So you cannot have a policy that actually maybe allows for sexual harassment. So you have to state, where is your policy anchored, or what gives you, in terms of the law, what allows you to have this policy, okay? So this particular policy, the legal framework is the Constitution, provides for right to fair labor practices, right to freedom. These are an extremely important part for your exam. If you're doing a policy in the exam, legal framework should be there, okay? So after setting out your definitions, your scope, you could even have objectives of the policy, stating what your policy intends to achieve. You could have that. And then your legal framework includes your constitution, the statute as well. For example, the Advocates Act, which provides that an advocate has to conduct themselves in a honorable manner, which is compatible with the status of an advocate. So that was important for purposes of showing them the legal basis of this particular policy. And then it has the Employment Act, which actually provides that defines sexual harassment, and workers should not be sexually harassed because employees in a law firm are actually workers there. And then also relies on the Sexual Offences Act, goes on and on about this particular act, the Sexual Offences Act. So many sections there have been declared unconstitutional. I'm not sure whether they've been deleted or what's happening, and then there is another bill which proposes to amend it further. But nonetheless, this particular act was relevant for this policy because it provides for sexual harassment, defines sexual harassment, and actually it's a criminal offense, okay? And then this act, Fair Administrative Actions Act 2015, states what administrative action is. It was equally relevant for purposes of, well, you might not have all these acts, but of course you might remember one act that is relevant to your policy, or one article of the Constitution that is relevant to your policy, and that has to go into your policy. And then the Occupational Safety and Health Act, that was equally as important. It has international law. So this act is big on legal framework of the policy. So it has that, and then it equally has the Law Society of Kenya, the SOPEC, because SOPEC provides for if you act dishonorably, and actually lists sexual harassment as a professional misconduct. But weirdly, you remember that person I'm telling you that I know, yeah? And their pupil master used to come with them to out of court station and then impliedly sexually harass them. They went and reported to LSK. And up to this date, nothing has ever been done. Nonetheless, SOPEC states that, you know what, these are professional misconduct. And actually, you should be at the advocate's disciplinary tribunal answering charges, because it's actually, it's dishonorable for you to act as such as an advocate. And then the other important part, so after your framework, legal framework, depends with what your policy is about. Of course, if it's an employment related policy, you will have the Employment Act there. And then you will have those articles of the Constitution in the Bill of Rights that relates to employment and employees. Okay, so you'll pick your legal framework depending on what your policy is about. And I'm positive that you'll remember one of the acts. And of course, you'll remember the Constitution as well, the articles that are relevant to your policy. So the other bit, after your legal framework, your policy needs to have roles and responsibilities. Now, you see, a policy is as good as useless if no one is enforcing it. So this policy has, or no one is told exactly what to do. Remember, as you were starting, I told you one of the major roles of a policy is to tell people to dictate your behavior. Yeah. So this one here, 6.1, it has employee roles and responsibilities. And then it tells you that every member, as long as you're a member of LSK, membership of LSK is two-tier. Yeah, you could be an ordinary member or you could be a special member. Okay, so whichever member that you are, you have to conduct yourself in a manner that demonstrates professional conduct. Don't engage or condone sexual harassment. But really, these law firms, God, Aki, I hope you never get to experience some crazy stuff out here. Now, you see, one of your favorite tier ones, where probably you've applied for your pupillage. So one day, so there's a guy who sits, their office is very close to the door. Okay, so every single time particular lady walks in, they tell them that they really like their cologne, they're smelling really, really good. So this goes on and on. In fact, those law firms, actually, I think most of them, you're not allowed to hug around the premises that, oh, your friends that you want to hug. There's no hugging, okay? So this chick tells him, hey, you're smelling so good, 1, 2, 3 times. So at one point, this guy gets annoyed, you know. I think it's only sexual harassment if you don't like that person. Otherwise, it was a compliment. So he goes and reports to the HR at CEO is being sexually harassed because he's been told he's smelling nice. Okay. Anyway, so you don't for him he was yeah, he was living up to not condoning sexual harassment at workplace and then participating fully and in good faith in any process of investigation. LSK, really, good Lord, those guys don't, especially if it's a senior, and then you go report.
What about in school?
What
about in school?
It is silent. This policy is silent on school. It's very specific on whom it applies to, and it doesn't apply to, it doesn't apply to, it has to strictly, it applies to LSK members, applies to during conferences, workplace. It doesn't apply to you guys. I think KSL might have a sexual harassment policy. I don't know, probably does. Anyway, so that's it. It has employee roles and what everybody's supposed to do. Sometimes law firms don't have any human resource, HR, especially the medium-sized ones or the ones, the startups. So the person who harasses you is the person you're supposed to go and report to, because the firm has one partner and 2 associates, and then the partner sexually harasses you. To whom do you report? You go and report to your harasser. But basically, whoever you report to has a responsibility of investigating and actually facilitating any investigations and consequent punishment of such harasser. Okay, and then it has management roles and responsibilities. What do we do? What we do at the top management of the law firm or the office? Adopt a clear written sexual harassment policy. Okay, really depends with your policy. This won't be your policy, you know. So you might have to maybe have roles and responsibilities for the cabinet secretary, because your policy might be different, or maybe have roles and responsibilities of farmers in Bungoma County, because a policy really is dictated by whom. The roles, responsibilities are dictated by whom it will apply to. And then it has complaints procedure, because for sexual harassment, you have to have a good complaints procedure, because victims are usually they're extremely they feel dehumanized, they're stereotyped, so the complaints procedure has to be a really good complaints procedure. How do you report? And then it has internal resolution of complaints. Can we resolve without really having to drag each other to the ADT? So the policy goes, so those are the substantive bits of the policy, including the reporting mechanism, because if your policy so a reporting mechanism depends whether you need it. It tells you a complaint to LSK, you use from number A. LSK has a gender desk. LSK offices are at Gitanga Road, Poko Valley Arcade. That it's like a 2-bedroom house which was converted into an office. I'm not really sure where the gender desk is, but somewhere, I'm not really sure whether it's physically there, or it's just some creature created by the policy. It's not there. And then it has remedial action, disciplinary action. Really, what can you do? But it's there nonetheless. Says that you could be debarred, and then discrimination is prohibited. Don't discriminate someone who has been sexually harassed. It has non-disclosure and confidentiality, because ideally, if you lodge your complaint at LSK, really, because the society, because of the way society is, no one is supposed to know about your complaint. We are just supposed to hear you out, privately, and then determine what action we are going to take. And it has to be an appropriate action. It has false malicious complaint. Those guys who like making false claims, even to an extent, it actually becomes like a criminal case, yet it's a lie. So the policy says if you make such a false statement, you'll be subjected to disciplinary action. And then it has a savings clauses. They're meant to make sure that what is there is not tampered with, like what is there regarding sexual harassment. For example, this one says an appropriate action can be taken under the Sexual Offences Act or the Employment Act. So savings clauses are meant to make sure that whatever we already have in terms of maybe punishment, because this act does its punishment is very limited, because if we report you to LSK can't lock you up in jail. Neither can they. The most they can do is maybe just debar you for a year, or maybe shame you on Twitter. Like, really, they can't do much. But under the Sexual Offences Act, you can actually be imprisoned. So the savings clause is meant to make sure that whatever is there, like this particular act, is to be read together with whatever we already have, the Employment Act and the Sexual Offences Act. And then it has a complaint form here. This is what you're going to use, and actually you can attach evidence if any. Interesting. So this is what you're going to use to lodge your complaint. Okay, so that's a policy. There is another policy. I have so many policies, but for you, I'm not sure which one. I don't know what might be examined there, but you just try to look at as many policies as you can. Because if you look at so many policies, then you're able to know what contents are appropriate for a particular policy, which is tested in the exam. But a policy the most critical part of a policy is whom it applies to, the scope, the objectives, the roles and responsibilities. And then equally there is another clause that I had told us when we were looking at those slides. It has to have a review, a clause for review. After how long are we going to review that policy and see whether it's actually working? That's an important clause. So it can't miss in your policy. So I'll share these other policies that I have. I want us to go back to that list that we had. I'm not sure whether you have any questions on policies. Maybe we could discuss regulations. We discussed regulations since we are in the space of legislative drafting. We could discuss regulations, at least a particular document to discuss regulations on from CLE's website. So let me get that document. Did you guys go through the exam expectations? That document on CLE's website, it's there. How to approach your exam. It's maybe let me show you where it is. Okay. I'm not sure where it is, but it's on their website. Okay, let me get that paper. I want us to discuss regulations using that paper because whoever did that paper, they scored a 10 out of 10, so we could use that. Oh, before we do that, allow me to share a question, a CLE question. Please just go to CLE's website and download it. I think it's called exam guidelines, something like that. Yeah, it shows you what exactly to do. Okay, just give me a minute. I check the paper. It's March 2022 April 2022, that's last year. So let me share it with you. And then we can go through it. And then we can go through regulations. Okay. Okay, so here it should be ATP 103. I think so. This is criminal. By the way, you guys might draft a policy or a bill. You'll either draft a policy or a bill, or you'll amend a statute. Yeah, this is a deed poll. It was question. Okay, so this is April 2022. Question 1 was a deed poll. This highly unlikely you might find that as your question 1. Okay. Okay, so here, who wants to read? We can read this super fast. Alafu, we discuss regulations. You guys will start drafting them. You know, you have to draft them. You have to draft them. Who wants to read this?
Question 5. Question 5. The state of Mecca is located on the East African coast. What are you doing? The state of Mecca is located on the East African coast. The economy of the country has been adversely affected by effects of COVID-19, political instability, and extreme weather conditions. Only recently, the Ministry of Land, Mining and Natural Resources delightfully announced the discovery of polymetallic nodules bearing nickels, iron, and diamonds off the coast of Mecca. The location of the discovery is well within the exclusive economic zone limit of Mecca. The process of exploiting polymetallic nodules, however, is unlike any other that Mecca has experienced. The technological aspect of it, the investment strategies, the financing, the aspect of the exploration that relates to environmental conservation are some of the aspects that the relevant ministries must explore and plan for. A. As Parliamentary Council intern in the Office of the Attorney General of Mecca, comma. Move it down.
Surely. Why are you reading a comma?
So to help you.
Okay, go on.
Evans.
Explain why a policy will be the most appropriate legislative step at this point. 2 marks. Should I read also the others?
No, no, we could attempt the first one.
Okay.
Yeah, of course, it's you guys who are attempting it. Why do you think a policy is the most appropriate legislative step? Like generally, even without this question, what's the importance of a policy? That's what the question is trying to ask. Come on, guys. Okay, let's ask let's ask, I don't want to seem like a bad person. You can type on the chat box, but I know you by names. What's the importance of a policy? Generally, like what would you say?
I'm raising my hand, you're not seeing me.
Oh, of course I can't see God. So sorry. You know, I'm on this other side of the screen, but please go on. Just unmute and go on.
I think one of the functions of a policy will be to bring about the regulation on how they are supposed to conduct, how they'll be conducting the mining in the zone of Mecca, where it is where it has its jurisdiction. Oh, yes.
Okay. Very well. Yeah, those are really good points. That would be your point number one. And then before you start answering it, you will start by defining what a policy is. Yeah, because for you to scope 2 marks, it's not it's not easy. So you have to start with defining what a policy is. So we'll say what a policy is in your own words. Really, you know it. You know what a policy is. Yeah, like you have an idea. So that is what you put in writing, what a policy is. So we said a policy is let me show you where that was. So we said a policy is a document which basically shows what people are going to do. Yeah, we said it's a document which outlines what a government or an individual aims to achieve for society. So that's basically it. So we'll start by defining what a policy is before you start telling us why we need a policy. In that particular instance, okay, I don't want to...
It appears that is a vision.
Huh?
It appears that what you have read us is like a vision.
Yeah, you could say that. Well, yeah, but now a vision in writing, you know? So it shows exactly what you want to achieve, who's doing what in order to enable us achieve. So you could say it's a document which outlines what a government or in this instance, what the government wants to achieve for the society, creates obligations, roles, responsibilities, and equally provides for what will be done in case a particular person doesn't live up to such objectives. It could equally have implementation mechanisms, So you just define a policy generally because you don't even have to remember this definition. As long as you have a policy is what you say it is. That is correct. Of course, it has to be along these lines, But I know you know what a policy is. So the other question asks you, why would a policy be important in that particular circumstance? So usually that's how CLE will set its questions, It won't ask you, for LWD, questions are rather straightforward. Okay, unlike these other units that, they beat around the bush, for LWD, they'll be quite straightforward, Why do you think policy is important? Of course, the simplest of answers is because it's so easy to formulate a policy, easy in terms of really, for a policy, you don't even need to, you don't need to use. It's easy to do a policy because you start with a paper. You start with a draft paper, which you present to the relevant department. So it is extremely easy to come up with a policy, and there is an urgent need, because right now we have political instability because of weather, and we have a mineral. And therefore, a policy will be the easiest thing to do because it is easy and speedy to come up with, unlike a bill, which has to be presented for the first reading, second reading, committee stage, and then taken to the whole house, you see? So for policy, it's super easy because, in fact, as long as you have a draft paper which you you float it to the relevant. These are a national issue. Yeah, you float it to the because it's a Ministry of Land, to the cabinet secretary for that ministry. They're agreeable. Then of course the next thing that you do is invite the public to participate. Include whatever the public tells you, and then ultimately it's approved by the CS, and then it's approved by the parliament, and then it's assented to. So it is it's an easy legislative process which doesn't involve very cumbersome stages, unlike a bill, because the other alternative would have been an entire bill, which will take forever. Okay, so and a bill has to be assented to by the president. This policy is not assented to by the president. It is usually assented to by the relevant whether it's the county or the parliament, and that would be it for policies. So that would be my first point. I will say it is extremely easy to formulate, and going to the agency to actually extract and apply these minerals for purposes of recovering from the political instability, extreme weather conditions, and actually putting the country back on its feet. I would use a policy. That would be my first point. I'm not sure what you're thinking, but whatever you're thinking is correct. I told us that those drafting questions, they have an answer. They have a correct and wrong answer because they have formats. But such questions, what is a policy? Really, as long as you're thinking along the line of it is a document which is used to achieve an objective, then you're correct. Okay, so don't even second guess yourself. Whatever is in your mind, it is very correct. So I'm not sure it has so many points. You could say, create responsibilities, so everybody in this particular country, state of Mecca, in regards to mining in this particular place, knows exactly what to do. Yeah, maybe whom to sell to, and the processes for refining such minerals. So everybody has a responsibility. Everyone has a role. So therefore, it means the policy creates a seamless process of actually being able to recoup some benefits from the mineral. You could say create some organizational structure, like there is a reporting mechanism in case there is you see that question, you would answer, you would just say anything as long as it makes sense and then explain, because everything is correct. Everything is correct unless and as long as you can justify it. Silio. Yeah, so you would use all those points. There are so many things you could say about why a policy is useful. The list goes on and on and on and on. Okay, so the second part asks you, do you think there will be need to have a bill in addition to a policy? Explain your answer. What do you think? Or rather, if you contradistinguish a bill and a policy, why would you prefer a bill other than a policy? Guys, acha niangalie hii list. The first name here is Alela. Unmute. Tell us why you think a bill. I mean, a bill is more important. Okay, or rather, do you think a bill will be important at any point? As I try to get, there was something I was looking for. Okay, Alela ameingia nyasi. Acha tuulize Amos. You guys, Amos, please go on.
Yeah, I think a bill would be okay to add to in addition to the policy, because as you mentioned that policies sometimes are not permanent and the enforceability is not also as strict. So I think a bill would be good for the permanence and also for it to be able to be enforced better.
Lord, that's super good. You guys mmenyamaza hapo lakini si elimu naona inawawaste time. Walete saa hii hiyo karatasi. That's really, really, really good. Lord, yeah, actually that's correct. those are the answers. Really, you know, as long as you know what it is, you know what it's not. Okay? Sasa kitu uko nayo ni correct. Bora una justify. So Amos, that's really good. That's superb. I'm so proud of you guys. Actually, I have no doubt that you'll do extremely well. There is something I wanted to show you because I want you to start drafting. You see, drafting goes beyond discussing. It's something which you have to sit down and actually do. Okay, so I want us to do regulations using a question, which I'm going to project. By the way, ebu go to CLE website before you even close your eyes at you. By the way, sahi hata ufai kuko unafunga macho. I'm kidding. There was a time, like the last week before the exam, there's a particular energy drink, ilikuwa 60 bob. Right now, I'm not sure how much it is, Lord. I abused it. Yeah. Unafunga macho, unakumbuka zili, wake up very and then there was a guy, his name is Brian. So in the middle of the night, we we used to have a discussion group. There were like 8 people. Yeah. So we used to wake up in the morning, join the meeting, go through a past paper, discuss some topics. So this particular, I'm still trying to get that paper. Oh, I've gotten it. So that particular guy called Brian, that we haven't finished that paper. Yeah, I think I'm doing a lot at the same time. Yeah. So as we have been told, let's finish this. And I'll tell you about Brian. So as Amos has answered, that's correct. You need a bill because of permanency. You see, a policy, no one even takes policy seriously. That's why, yeah, yeah, we have so many policies, but no one takes them seriously, okay? But now a policy is not able to create offenses and their punishments. That's the number one disadvantage of a policy. It doesn't have offenses and it can't have punishments. So really, if people just do, if maybe it says for a mineral, before you actually start extracting it, you have to get a license from the government, and no one gets a license, you know, a policy will be so, you know, it's like it's, you see how you put your phone on sleep mode, but it's still on. That's a policy for you. It is there for the sake of, it's so relaxed, you know? So it doesn't have, it doesn't, you know, you can't draft a charge sheet and then you write there at you're stealing in dissonance with a policy. There is not, a policy is unable to create offenses, it can't create punishments. So people don't take policies seriously in this country. Yeah. And then of course the history is replete with, we have so many policies. We have tendering processes, policies for the Ministry of Defense, but no one ever takes those things seriously. People just ignore them because they're not serious. And they're serious. And then as a policy cannot establish an office. We might maybe need an office for purposes of licensing miners. I mean, people who are mining bodies, mining corporations. So we might need a body for licensing, maybe reporting incidences, maybe for purposes of assessing maybe environmental impact assessments, seeing whether after you mine, you have to restore the land. So what happens to that land after you mine? You leave there really big holes, in their animals which drink water around that area, their children who go to school. So what happens to those holes that you leave there, you know? So if you create such a body that is able to maybe follow, like a bill, you can create an authority. You could say mining authority, you know? You can create a mining commission. But now in a bill, you can't create a body, you know? So, I mean, a policy, you can't create a body. A bill, you can create a body for purposes of proper enforcement. And equally, a bill is useful for purposes of funding. Using a bill could actually have its sources of finance. The last part of a bill, usually called final provisions, you could have financial provisions where among sources of our funds includes from the national government. We have a budgetary allocation for purposes of that bill. Maybe we need to purchase some mining, some mining instruments. Okay, that's not correct. I don't know what you call them, but they should have a name. Things for mining, you know? We might need that, but we don't have money to purchase, you know. So those are issues for consideration. Why we need to have a bill? It's because of issues of permanency, because of funding, establishing offices, proper accountability in terms of offenses and punishment, such things. The list goes on and on and on and on. So Patsy asks, discuss the main legislative steps to be followed in policy making. See, we discussed that. Yeah, there is initiation, and then you go to research, and then you go to public participation, approval by the cabinet secretary, approval by the parliament, and then assent, and then publication. Okay. Sawa. So I was telling you guys, I wanted to show you something. Let me show you, because at least we can tick off 3 documents from that list every day. So let me get it. I've seen a really good policy here, but it's too lengthy. But I'll share it with you nonetheless. Yeah. So I was telling you guys about my friend called Brian. So Brian, so that group, we used to wake up, discuss in the morning. Used to be mornings. So Brian, I remember it was 2 days to the exam. So Brian wakes up in the middle of the night at around 3. Of course, 3 people are up, maybe reading, but Brian can never ever get up at 3, even if the house is on fire. So he gets up at 3, and then he starts calling people, like he video calls the group. So there is that option on WhatsApp, like you can call everybody. So that is what he did. So, so when Brian called, he started saying he's sweating and he's shaking. He can't control. He's shaking and he's sweating. He's really sweating. Things are bad. So, tough times, So, of course, I laughed. I laughed. Me, I had no advice for him. But there was a guy called Suka. So Suka advised him. He told him, oh, it's never that serious. Take things easy. But we know it's serious. Yeah? So Brian says he's sweating. He doesn't understand and he's shaking. Yeah? Yeah, Lord. PTSD when I remember tough times. So don't be like Brian. Okay, there was something I wanted to show you. It's question 5. It's question 5 of this paper. This is June 2021.
Did he pass?
Brian
Did he
passed.
pass?
Brian did really,
Okay.
really well. Yeah, he did really, really well. Right now, he's a prosecutor. I don't know how he
Nice.
got there, but yeah, but he works for the ODPP. So Brian, you know, he was like profusely sweating. It was, you know, you get those scares, like you get really, really scared, which is actually allowable. And you know, Brian was one of those strongest persons. He doesn't want people to see him feeling bad about situations, but it got to him, and it was interesting. But you have to find a coping mechanism. I think these days, like these last days, like 2 weeks, 3 weeks to exam, pressure can be overwhelming. You know, you have a lot of expectations. You're seeing new things you've never seen. You're seeing them right now. You have to have a coping mechanism. Really, don't let it get to you. Yeah, just let yourself breathe. All right, because when you start studying under pressure, what happens is you won't understand anything. By the way, you'll be fidgeting. You'll do nothing, or you might think you've actually done a lot, but you've done nothing. So make sure no matter what happens, you're very calm. Just stay calm. I'm not sure what your groove is, but you have to stay calm. You have to really, really stay calm and collected. Otherwise, God, utakuwa unashika hii kitabu, unakumbuka nini? Bankruptcy, unatafuta bankruptcy, unakumbuka bill, unafungua bill. Karibu uweke vitabu huko kwa roof, because zote zimejaa kila pahali. So make sure you're very collected, you're calm. Find something to do. Don't sit from 8 to 8, okay? you'll be wasting a lot of your time. Okay, you're not wasting per se, but you might be unproductive if you reach a particular point of saturation. So you find a coping mechanism. I really don't know. You know, this profession has, even after Kenya School of Law, it gets worse because the pressure increases. Now you have real people in, like you have real clients who have real genuine problems, okay? So the pressure increases, it becomes worse. So you have to find a coping mechanism as early as now, okay? You know, don't be like me, don't abuse energy drinks. I really abuse, that energy drink used to be called, it is like a tiny yellow drink. I think that shopkeeper knew me. Akiniona hapo ananiuliza ngapi?
Saa nne ishafika.
So, okay, acha nionyeshe kitu tumalize class. One last thing. So this is question 5. So find a coping mechanism. Don't use comfort food. After these exams, you'll be very fat and you'll regret why you did it. Don't abuse energy drinks. If please don't do it. But I really had to. I was so sleepy. So see, it's question 5. Question 5, but just find something to keep you distracted for a bit if you're saturated and you're tired. Okay. And don't lose yourself. Do not lose yourself while at it. Really, I don't want to say it's never that serious, but you know, after you pass, you'll be like, what were you stressing over? Well, of course, you're supposed to stress, but not too much. Like this kidogo. Don't be too hard on yourself. Like, sasa hata ukuli, ufungi hata macho. Yeah. You know, if you do that right now, you'll burn out towards the last 1 week. And the last 1 week, you're supposed to be super, super alert. So right now, you can give yourself hours of sleep. I'm not sure what kind of timetable you're working with, but my timetable was, I used to study 1 unit a day, like a full day, 1 unit. I never used to study a unit for 2 hours or 3 hours because I figured that is so unproductive. Like you see, for let's say something like commercial, really you can't even finish a topic in 2 hours, you know? So I used to set apart a full day for 1 unit. Okay, and then I'll focus on that unit. So towards the last days, I focused on what I felt like I didn't know, and I needed to do a lot in that area. For example, I remember I was so stressed weirdly about trial advocacy. So I used to read trial advocacy a lot. There's a book I sent to you. That is the book I was using, for trial advocacy. But just prepare a timetable, and then the timetable should have those places you feel like you're not good, like you know yourself. If you're genuine with yourself, you know, like for real, hapa civil nahitaji kuweka more effort. And then you now in your timetable, I would advise you to study a unit a day. It's a good strategy. Otherwise, 2 hours you might not cover ground, or you might. It might work for you, but you have to make sure. I don't know how that works. 2 hours a day for each unit. Just use a day for 1 unit. You know, these units are very expansive. You need a lot of time to cover base in 1 unit. Okay, so you can focus on that which you feel like you're really, really weak, and then kidogo hours on that which you feel like you can handle. Okay, but don't neglect them. Even if you think like you know a lot of commercial, don't neglect it entirely, because if you neglect it, you might don't be overconfident. That's what I'm trying to say. So make sure you're reading everything, but paying attention to what you feel like you're weak at. So, yeah, but don't lose yourself while at it. This isn't if it was a dunia bana. People, Gaza is on fire, you know. We might actually but you just read, but don't take it too seriously. Like a matter of life and death. Okay, so this is the question I'm telling you about. It's regulations. Regulations, we haven't read that question, but this is how they are done. This is the format of regulations. It's like a bill. Of course, you've seen regulations before, maybe insolvency regulations or Section of Properties Act regulations. So it's like a bill. It takes the format of a bill, but usually it doesn't have it's not as comprehensive as a bill. In fact, it has marginal notes. You see these marginal notes up candle, okay? So it has a title, and then it has what you call, I'm not sure they can remember what you call a table of contents. It has this, yeah, citation, interpretation, prescribed fees, and then offenses. So this is how you draft it. You draft it like a bill. Yeah, by the way, even definition goes into part 2 of your regulations, as it will have for your bill. So you could look at these regulations because it's already 1026, and then see how you would have drafted them, but the format is that of a bill, and the format is actually here, because these draftings are all about formats. If you can remember these formats, then you're good. The content won't be a problem, because the content will be there in black and white. I think this guy, whoever this was, they got a 7 out of 10. It has to be signed off. Yeah. If you check regulations on Kenya law, you'll see the last bit here. There is something which is usually written. Let me get you some regulations. Oh, I'll share them with you. But you can easily find regulations, So that's how you will draft regulations like a bill. The content of the format of a bill, including marginal notes, and then definitions. You will use the rules that we used while you were drafting a bill. Okay, so attempt that question. Nonetheless, we'll discuss regulations. Let's look at that list, and then we tick off what we've done for purposes of organization, yeah, to enable us know in the next class where we are picking from. So let's see. Let me just delete this for a very particular reason, because you guys might ignore it. You see, is okay. So far there's a bill and amendment bill are the classes that we've had, I think, over the last week, part 1. So we've done a policy, and then we have done a case brief. So let's tick this, just highlight in yellow. So what remains? What else have we? We did these classes a while back, though, but we'll repeat them nonetheless. So you will now embark on drafting a case bill. I mean, a case brief, the entire case brief. You could get a blank notebook and then call it LWD drafting. So you draft each of these documents using a pen. And when it's by the way, it's like this, it will be there in the exam, and it will be a lot of marks. Of course, I know it's one of these documents, and it will be a lot of marks. Actually, there might be 2 documents. So you are going to draft each one of those using a pen. Understand the format. Each of these documents has a format. All of them, they have a format. Okay. So in the next class, we draft what's remaining. And then regulations, I've told you to check that paper. The paper is, I think, June 2021. It has a question on regulations, the best performed paper on CLA's website. See how to draft a regulation. And then we'll start with that in the next class, how to draft regulations. And then we go to legislative instructions and then cabinet memoranda. After we finish that, we do other draftings. Okay. Okay, guys, I'm not sure whether we have any question. If we do not, we finish the class at that point. Thank you so much for the indulgence. I'll see you guys tomorrow. You can draft and then you DM me. I'll try respond promptly. I will respond promptly, because now I understand the exams are around the corner. But thank you so much for the indulgence, guys. I'll see you tomorrow. Have a lovely, 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 lovely night.